Costly application mistakes. Here are 9 of the most common mistakes companies make when applying for an L1A visa that you can avoid. Number 1, filing prematurely. Companies often file for L1A visa before they are ready, meaning they don't yet meet the technical requirements. For example, a company may set up a new office, but they are working out of a co-working space with a subscription agreement instead of a traditional lease. That may not work. I have seen companies file prematurely for everything from entitlement to desperation, but it doesn't change the fact that there are fundamental requirements that have to be met, or a lot of money, time, and effort is going to be wasted filing out an application that is doomed to failure. Costly mistake number 2 is that they hire attorneys that are not experienced with L1A visas. Immigration is a broad field, and many immigration attorneys have no experience with the application and evidence requirement necessary to get an L1A approved. For example, it is very easy for an inexperienced attorney to simply trust the evidence provided by the client and miss small inconsistencies that could be simple translation error, yet jeopardize the entire application. Costly mistake number 3 is applying when the foreign company is not large enough. L1A visas are for executives and senior managers. That will be hard to prove in a small company with 10 employees. These executives may have the title CFO, for example, but if they're really serving as the controller or bookkeeper, they're likely to be denied. Costly mistake number 4 is showing inconsistencies in the records. We have discussed several examples of this already, and there are more. The key thing to know is that inconsistencies make all the evidence in the application unreliable. And when all the other technical requirements are met, these inconsistencies become the most common reason for a denial. Costly mistake number 5 is not clarifying major point at the beginning of the preparation process. I have seen many examples where at the beginning of the process someone was referred to as general manager and the company was listed as a subsidiary of a company X. But later in the process, things changed to CEO and the subsidiary was of company Y. These are the types of things that drag the process out and lead to the inconsistencies. Costly mistake number 6 is demonstrating a lack of capital. Typically, when a company is applying for an L1A visa, they are also hiring several people that their visa applicant will be managing. However, if the US company can show significant investment funds, USCIS will often believe the company incapable of supporting the executive position and deny the application. The 7th costly mistake is simply not providing enough evidence. A common example of this is when a company cannot supply enough evidence to show their applicant was legitimately in a managerial position in the foreign company. It takes far more than just a job title. Costly mistake number 8 is filing the application too late. These applications are often over 1,000 pages long once all the evidence is gathered. Waiting until the matter is urgent doesn't only necessitate the premium processing fee, it also greatly increases the risk of filing an application with mistakes and inconsistencies. And costly mistake number 9 is simply overlooking clerical errors on forms. It can seem extreme, but it is not uncommon at all for typos on the actual immigration form to result in a whole application being derailed. As you can see, there are many ways to mess up an L1A visa application, which will not only be a huge waste of time, effort, and money, but will also delay you being able to bring the employee you need. To make sure you avoid these mistakes, make sure you are working with an immigration attorney experienced with L1A visas like me, Iskra Panteva, founder of Panteva Law Group.